you potentially have a contemporaneous record of all your employment decisions, of what factors went into it, and be able to justify why you asked the algorithm to look at the skill, because this is from our business judgment, which of course you're allowed, and our industry standards. This is the most important skill for the job. And if it causes discrimination, there's some times that you can justify that based upon your applicant pool.
Good morning, good afternoon, or good evening, depending on where you're listening. Welcome to AI and the Future of Work, episode 307. I'm your host, Dan Turchin, CEO of PeopleRain, the AI platform for IT and HR employee service. Our community is growing. I get asked all the time how you can meet other listeners. To make that happen, we recently launched a newsletter where we share weekly insights and tips that don't make it into the podcast, as well as opportunities to engage with this amazing community. Go to aiandwork.beehive, oddly, with two I's and a V, no E, .com/subscribe to register. It's free and not spammy. We will never share your details without your permission. And of course, we'll also share that link in the show notes. If you like what we do, please tell a friend and give us a like and a rating on Apple Podcasts, Spotify, or wherever you listen. It helps other listeners discover this podcast. If you leave a comment, I just may share it in an upcoming episode, like this one from Dominique in Billings, Montana, who's in marketing at a fintech startup and a mother of three who listens while driving the carpool. Dominique's favorite episode is the one with Denise Hemke. I love that one as well. Former Workday GM, about using AI to reduce bias in the hiring process, which it turns out is super relevant to today's discussion. We learn from AI thought leaders weekly on this show. The added bonus, you get one AI fun fact each week. Today's fun fact, which is also very relevant to today's discussion, Erica Sweeney writes in Business Insider that employers using AI for hiring must still comply with all labor practice laws that address discrimination. Companies need to know where their data is coming from, what the tool does, and why they're using it. Employers must be prepared to answer, do you have data that will actually get you the outcome that you're seeking? Is the tool assisting you in getting the best person for the position without discrimination? Sweeney interviewed labor attorney Amanda Blair, who said there need to be clear definitions. What's an automated employment decision tool? What is artificial intelligence applied in this domain? Clarity in any rules is key because that's going to be one of the biggest barriers to enforcement. Ignorance of the law is not an excuse. Of course, we'll link to that full article in today's show notes. Now, shifting to today's amazing conversation, Commissioner Keith Sonderling was confirmed by the U.S. Senate with a bipartisan vote to be a commissioner of the U.S. Equal Employment Opportunity Commission in 2020. Prior to his confirmation to the EEOC, Commissioner Sonderling served as the acting and deputy administrator of the Wage and Hour Division at the U.S. Department of Labor. Before joining the DOL in 2017, Commissioner Sonderling practiced labor and employment law in Florida. He also serves as a professional lecturer in law at the George Washington University Law School, teaching employment discrimination. Since joining the EEOC, one of Commissioner Sonderling's highest priorities has been ensuring that AI and workplace technologies are designed and deployed consistent with long-standing civil rights laws. He's published numerous articles on the benefits and potential harms of using AI-based technology in the workplace. Before his government service, Commissioner Sonderling was a partner at one of Florida's largest law firms where he counseled employers and litigated labor and employment disputes. Before we start the conversation, thanks to friend of the podcast, great former guest and PeopleRain investor, Thomas Otter from Acadian Ventures for the introduction. And without further ado, Commissioner Sonderling, it is my pleasure to welcome you to AI and the Future of Work. Let's get started by having you share a bit more about that illustrious background and how you got where you are today.
Well, thanks for having me, Dan. And I'm really honored to be on this podcast with all the other esteemed guests you've had here. Many of them are my good friends, and I'm really looking forward to share my perspective. So first, you asked me about the personal side of me. As you heard from the background, I was a labor and employment attorney in Florida defending HR departments when they'd get sued or the EEOC or DOL came after them. So that gave me a unique perspective coming into government, which is a once in a lifetime opportunity to be able to enter the government at the Department of Labor like I did, and then get nominated to be commissioner of the EEOC. And it's just been an incredible experience. And I like to say I came to Washington, D.C. from Florida to get a PhD in labor and employment law, because certainly when you are running these agencies and dealing with the entire scope of not only all the laws, but from the entire nation and regulating almost every industry, you really learn a lot. So at the EEOC, where I'm just about to wrap up my term as commissioner, these are term appointments. They don't last forever. You have to be confirmed by the United States Senate, which I was in 2020. And I always just wanted to do it one time, make a significant impact, and not go for a second term. So I'm glad we're chatting on my way out, because I have a lot to say. So for those of you who may not be familiar with this agency, I know there's a lot of government agencies. The EEOC really, like I like to say, and I'm biased, is the crown jewel of all labor agencies, because it deals with the most important issues. For all purposes, it is the regulator of human resources. So think of us as that. Basically, everything HR professionals do on a daily basis, from hiring, from wages, training, benefits, promotions, we are the regulator of that. And what's so special about this agency that a lot of people don't know, and why we are revered worldwide, and why a lot of other countries have set their standards around the EEOC, is that this agency was born out of the civil rights movements in the 1960s. Martin Luther King marching here in Washington, D.C. led to the creation of the Civil Rights Act, which we all know of. But that act also created the EEOC. It also gave applicants, employees, and former employees some of the strongest workplace civil rights protections in the world. And that is to not be discriminated against based upon characteristics such as your sex, your national origin, your race, your color, your religion, disability, really everything HR professionals have dealt with. The protections are from this agency. So when you think of our agency, you're thinking about all the big ticket items you're dealing with, whether it's the DE&I, the Me Too movement, pay, that's us. So it's really, it's an incredible agency with a huge reach. And like I said, most countries, because we were the first really to do it, to guarantee those civil rights protections in the workforce, have mirrored a lot of their laws and protections around us. So that's why we have such a significant global impact.
So super naive question, but I'm going to ask it anyway, because maybe some listeners have it as well. If I'm let's say a candidate or an employee, and I suspect that maybe I'm being discriminated against, what are the telltale signs, and what do I do about it?
Well, it is so, I'll be a lawyer here. It's very fact specific, right? It all depends. But, what's interesting, what's important to know is that in the United States, for most employment claims, you cannot sue your employer directly in court. You have to come to the EEOC first. So whether you work for a private company, state, local, or federal government, you have to come to us for us to do an initial investigation, or sometimes take the cases ourselves. So that puts us in a position of seeing every type of employment discrimination case in the US, what the trends are across the board in certain industries. So that, as the gatekeepers for that, really gives us a lot of knowledge and information related to that. So if an employee or applicant feels like they're discriminated against, the first thing you do is you reach out to our local offices. We have local offices all around the country. As you can imagine, we're a big organization and a civil law enforcement agency. So I don't personally handle all the 800,000 potential inquiries of employment discrimination that come in every year. We have frontline officers that help you determine whether or not it's actual discrimination, and if it's actually tied to a protected characteristic, that employment decision that may have bias or discrimination in it. And then that's weeded down to see if you actually want to file a federal charge of discrimination against your employer. So that turned into around 80,000 actual charges at the EEOC last year. So like all of you in HR, you have a very important role of doing a lot of screening, doing a lot of saying, well, this is not necessary and lawful. This is maybe something else. We have to do that as well, because we have people coming to our offices, emailing and calling us.
So as we've learned on this podcast from mutual friends like Art and Juliet and Thomas Otter and Josh Burson and John Boudreau and other legends in the field, increasingly AI is becoming pervasive throughout the HR process. Essentially every domain, from selection through to performance evaluation, talent management, learning journeys. And yet, as I referenced in the AI fun fact, that does not absolve employers from complying with the underlying laws. What do you see as the risks of these technologies automating tasks that have always been the responsibility of humans?
Well, you so eloquently talked about how AI is all over the place in HR, and even more. It's every function of HR, A to Z of the employee-employer relationship. There is some AI out there, as you know, promising not only to make those employment decisions more efficient, more economical, based upon data, taking a skills-based approach to hiring, all these things that we've heard constantly. But what has been so important for me here since I've been an EEOC commissioner is to make AI and HR one of the top priorities of the agency. And before I answer your question, I just really want to give light on why I spent my time as commissioner focusing on HR technology over everything else we have to deal with. Because in HR and in compliance, just like the EEOC, you are constantly putting out fires. You are constantly going in different directions depending on what's going on out of your control in the news. So just a really quick, brief history. If you look about from a compliance perspective, after the recession in 2008, between 2010 and 2012-ish, there was a huge amount of reductions in workforces. And older workers were disproportionately impacted by that. So then there was a spotlight on age discrimination and how we make sure older workers can stay and come back into the workforce. Then the Me Too movement happens, and all resources have to go related to sexual harassment prevention. Then the U.S. women's soccer team with pay equity. Now everyone's talking about pay. Of course, all these things have, long-standing laws from the 1960s. None of it's new, but the focus changes. And then COVID, and then it was about accommodations and vaccine mandates, and George Floyd, and it was about racial injustice in the workplace. So there's always going to be that significant distraction, not only for you as HR professionals, but us here at the EEOC of where we have to spend our resources. So knowing that, I really want to say, how are we going to get ahead of the next Me Too movement? How are we going to get ahead of the next catastrophe that HR professionals are going to have to deal with? And that's where I started diving into this when I realized how prolific it was and how many different options there are for HR professionals, whether on the talent side, the management side, the accommodation side, you name it, to have AI make those decisions, not just more efficient and economically, which I just said, but also to remove bias and thinking that these artificial intelligence tools can be designed to eliminate the biggest problem in HR, which is the humans, which have caused the bias, which is the reason my agency exists and continues to exist. In the last 2 years, forget about robot discrimination, which we'll talk about in a moment. Let's just talk about the state of everything. I told you there's 80,000 cases every single year. That's increasing. In the last 2 years, we've collected $1.2 billion from employers for violating these laws, right? Before we even know about these AI cases. So there's already an issue here. So you have a lot of very smart people, much smarter than us, that can design this AI with that in mind. And, I've taken the approach that if AI is carefully designed and properly used, it may be able to help us eliminate some of that human bias. But at the same time, you could just flip what I said. If it's not properly designed, or if it's not carefully used, which are two separate and distinct concepts we can talk about, because some is on the vendor and some is on the corporation using it, that it could potentially make discrimination larger and scaled than any one individual can do. So after I dove into it and realizing the pressures that everyone in HR departments, that everyone who's designing, developing, and deploying these products face, it says, okay, well, how do we set the guardrails around this? How do we now talk about as an agency, knowing that this is where HR is going? How do we discuss what our role is? How do we discuss what the law is? And what I found, there was significant, massive confusion about the law. And that's why I've been so aggressive in the HR tech space. That's why I've been so aggressive in the HR world, to make this boring, to simplify this. And let me tell you why. Yes, there's a lot of new legal proposals, and it's causing confusion of what you can use and what you cannot use. And I'm happy to talk about some of those. But at the end of the day, I've simplified it in saying there's only a finite amount of employment decisions: hiring, firing, wages, training, benefits, promotions, right? And your company is making those decisions whether you're using AI or not. But that's what the law regulates. And it has regulated since the 1960s. At the end of the day, whether you're using these tools to completely make that decision, whether you're using the tools to augment that decision, or any of those other buzzwords we're hearing, right? Assist, human in the loop, all that, that doesn't matter to us. What matters to us is the employment decision and whether or not there's bias in that employment decision. And that is what we're going to look at. And that's what our laws apply to, is the employment decision. And AI hasn't come up with a new employment decision yet, right? So in a way, how do we simplify this as a law enforcement agency, a regulatory body that is responsible for now diving into this? Is we have to look at it the same way we've looked at everything else. And is that decision the employer made based upon the business need, based upon merit, all these lawful factors, or did bias come into play? And I've argued that AI can help make it better and can potentially make it worse. It all goes back to the design and the use.
That's an excellent answer. And we got to unpack a couple of those themes. So when it comes to assigning liability for these decisions that are in violation of the law, one of the things that always is unsettling to me about these conversations is that everyone has plausible deniability. The LLM vendor says, all we're doing is encoding bias that's already in the data. We're not biased. The model's not biased. It's just replicating human bias, right? And the owners of the data say, we didn't even know our data was being used. Not our fault. And the vendors say, we got the model. The LLM came from the foundation model owner. It's not us. The bias is in the model. And then the customer says, look, you all told me you were going to keep me safe, right? I'm not responsible if this technology ends up violating laws. From the perspective of the law, maybe, not so much where we're at, but where we're headed. How do you unpack that and figure out who's ultimately responsible?
We're also forgetting another group here, which are the consumers. And who are the consumers in our space? Applicants, current employees, and former employees. And that's our job here, to make sure that they're in the discussion too, because ultimately they're going to be the ones subject to these tools. But let me sort of respond to this, because it's really important for everyone to understand. And it's different in HR than it is in other areas. And let me tell you why. So when the Civil Rights Act was passed in 1964, Congress said that only 3 groups can make an employment decision in the United States. You can only have 3 different kinds of employers. Companies, obviously, staffing agencies, which, in this area, we know very well, they're considered employers, and unions. That's it. Nobody else in the US can make an employment decision. So here we are, fast forward in 2024, where all these AI vendors are essentially either doing it, helping employers do it. What's their liability? And the answer is, from our perspective, none. The vendors are not going to be liable because only you can make the employment decision. And that's where it stems from. And, the companies in the middle, who are obviously the buyers of this, who run the risk of using it, well, the vendors can use their own tool on their own employees, and then they'll be an employer. But for the most part, the employer is using the tool to make an employment decision on their potential workforce or their workforce. So you have to understand that. And it's not like that we're just picking on the companies. That's just what the law requires, who we look at. Okay. So that being said, that is not like other areas where you have product liability. So you may be using AI in different areas of your company where the vendor may have some responsibility. And that's how a lot of these programs, especially in the SaaS software space, are designed and sold, to say, here you go, it's an off-the-shelf product, use it, and it's going to be more, you're going to make decisions faster, your shipping routes will be faster, your logistic warehouse will build widgets quicker, a lot of the other uses of corporate AI. But in the HR space, it's different. And why is it different? Not only because the law says it's different, but you're dealing with some of the most fundamental civil rights we have in this country, which is the ability to enter and thrive in the workforce, provide for your family, and not be discriminated against. So it's just a different way of thinking when you're using AI in HR than other parts of the business because of the way the law is. So what does this now require for you as buyers of these softwares, of deployers of these softwares? It's such a heightened risk that you need to take. I'm not saying you shouldn't take it, because as you know, I'm a believer in the software if it's properly designed and carefully used. I do think this will help us. I don't think it's a question anymore. Are you going to use AI in HR tech? I think we're way past that. The reframing of it is, how are you going to use it? What purpose are you going to use it for? What are your existing policies, procedures, and practice? How are you going to work with the vendor to ensure that that is going to happen. And most importantly, how are you going to comply with civil rights laws? So that it's just a different question when looking at what to buy and implementing it, because you're going to bear that responsibility. So it's a whole different dynamic on the front end of working with the vendor, picking the right vendor to ensure that their product is going to do what it says it does, not in the aggregate, not in the sales pitch, but for that job description in that one part of the country with that workforce to see if it is getting you the best candidates or if there's something in there, and it could be the data, it could be the use of it that is going to discriminate against certain groups. So, as complex as this gets, I just keep going back to the 1960s and saying, here's the standards for employment practices. And it's not changing because at the end of the day, there's an employment decision.
You didn't equivocate for even a nanosecond. And in so doing, Commissioner, you just made friends with all of the tech community and the venture capital industry. So then it's encouraging that you feel like these things were encoded in law in the 1960s, and employers are still going to be held responsible for the hiring decisions.
I just don't want the agency lawyers to use this as an excuse, saying, the EEOC doesn't have laws related to AI. We can't use this. We can't implement this. Okay, then you're going to stick with the status quo. And you just heard about the status quo. And in that narrative, again, having the benefit of being in private practice, having the benefit of seeing how difficult, both from the private side and now in the government, these employment investigations are. And let me just, you asked earlier about what employee does if they're facing discrimination. Well, what do our investigators have to do? So forget technology. Our federal investigators show up to your business and they say, you were just accused of systemically not hiring, let's just say, pick your protected characteristic. We'll just say older workers, right? Female older workers, it gets very granular. Is that true? Do you discriminate against female older workers? Nobody ever, very rarely admits employment discrimination. What HR professional, what person's can say, of course, EEOC, we don't hire older female workers or whatever the category is. So we have a very difficult job to begin with. And you want to talk about the black box of the algorithm? We're dealing with the black box of the human brain, which is even harder to destruct than potentially transparent algorithms. So I've been trying to flip the narrative, both from a use perspective and a law enforcement perspective, that again, if everything's right, and I'm going to say it until I can't speak anymore, if the AI is carefully designed and properly used, then you potentially have a contemporaneous record of all your employment decisions, of what factors went into it, and be able to justify why you asked the algorithm to look at the skill, because this is from our business judgment, which of course you're allowed, and our industry standards. This is the most important skill for the job. And if it causes discrimination, there's sometimes that you can justify that based upon your applicant pool, based upon where you are, based upon a certain skill that, people have. And that's why we got this result. Not because we were intentionally discriminating against this group, but this is all we asked the algorithm to look at to find those people with those skills. And this is all that's there. So we don't have that now. When you're faced with a law enforcement investigation on this, what happens? And that's where, before I got into the space, everyone in HR just EEOC, run away, never talk to an EEOC commissioner, something bad happened, right? That's most HR experience and legal department experience with the EEOC, right? We're being accused of now something. So, to flip this and saying, well, how do we use AI, carefully designed and properly used, to then disprove what we're being accused of? Because we worked with the right vendors. We know that their software was able to mask whether the applicant was male or female, whether the applicant, had any indication of what country they're from there, and only look at these skills. And we, at the time, in our best business judgment, these were the skills necessary. And it wasn't discrimination. We don't necessarily have that right now, because a lot of times when you're faced with a law enforcement investigation, lawyers get involved and you're backtracking sort of what happened. So, I've been trying to show, again, the positives on this as well, in ways that people may not be thinking of the use or stick with the old fashioned way. But again, it's in this position, I have to be very balanced, because I can tell you all the benefits of any AI HR software, how it can eliminate bias, how it can eliminate if, knowing that the employee is pregnant or disabled. And at the same time, I can tell you that, flipping what I always say, if the vendor didn't design it right, or the vendor designed it right and the company used it the wrong way, let me tell you how it's going to scale discrimination. Let me tell you how it's going to show national origin discrimination, age discrimination, you name it. So you just have to take a very balanced approach and saying, before you're saying that, oh, it's the most revolutionary thing to ever happen to HR, which could be true, or it's the potentially worst thing to ever happen to civil rights, which could be true. You just have to understand the context of your specific use, because every company's use is going to be different. Every vendor's design is going to be different. And that's the most challenging part, where we haven't really figured out yet, with the amount of software out there, with the amount of vendors out there, with the amount of investment, is everyone wants, to be the best product in this specific space. But it's so hard to say that without seeing how it's used in different job descriptions, in different employees all throughout the country when the parameters change.
So we've been talking about the employer side and even the vendor side to some extent, but you alluded to what's really the most important set of constituents, which is the candidates and the employees. And you correct me if I'm wrong, but I think that this next topic hasn't been adjudicated, which is, as a candidate or an employee, what level of transparency should I have, or what awareness should I have when an algorithm made or influenced the decision about my promotion, hiring, not hiring, et cetera?
This is a great question. This is part of the debate. Now kind of moving forward, that the old law, our laws are old, but they're not outdated. They apply to all these decisions. Let's talk about the reality is, it's easy for me to say that here in Washington, D.C., in the executive branch, where I can't make laws. We enforce laws, right? Let's go back to basic civics here. You can't ignore what states, foreign governments are doing in this space, or what's saying specifically, if you're going to use AI in HR, here are the additional requirements are going to be. But let me just tell you, from a federal law perspective, there's no requirements to disclose if you're using technology. There's no requirements to disclose to candidates anything. Think about it. Before, all this HR tech was out there, you applied for a job, you had an interview, we went with somebody else. Unless, you can show some evidence of discrimination, what does the employer have, after suing them, basically, what does the employer have to tell you now about whether or not what they're doing, assessing you, forget, just in a room, sitting across the conference room table? Nothing, right? When has that ever been disclosed? Never. So that's why in the HR tech space, now that we have these advanced algorithms potentially running when you're on a Zoom interview, whether they're looking at facial recognition, whether they're using natural language process to see the way you're responding to answers, right? And there's no federal requirement for consent or disclosure. But this is where you're seeing the states aggressively starting to get involved. And just a really brief history of here, the AI governance, AI regulation space is hot across the world. What is really particularly interesting is one of the first areas, whether you're in Europe or whether you're in New York or California, that the legislators want to dive into is in our world, is in HR. So the first AI HR law actually was in 2020 in Illinois, that essentially banned the use of facial recognition during video interviews. Maryland filed suit not too long after, but that's a very specific use. That's not broad. It does tell you, if you're being subject, if you're an applicant in Illinois, working for an Illinois employer, that facial recognition may or may not be used, and you could opt out. But it was really New York City with local law 144 that was the first one to say, we're going to regulate in this space if you are an automated employment decision tool. And, the definition of that was very up in the air, is saying, well, it basically has to make the decision or rank the candidates and selecting, and then you're an AEDT. But if you use it as one of many other factors, you're not subject to it. So let's assume you're subject to it, and then you actually have to disclose potential consent, pre-deployment audit, yearly audit on some of those issues, and just how complex this is getting. So if you're in New York City, you may say, well, we did this audit, we're doing this consent requirement, disclosure requirement, we're good. Well, you're not, because the New York City law only requires those pre-deployment audits or the consent and notification on hiring and promotion, and it only requires you to audit for race, sex, and ethnicity, where the EEOC covers all employment decisions, also covers disability, sexual orientation, age, all these different things that, if you're going to audit for those to make sure it's not discriminating against those, that doesn't mean you're going to get off the hook from us. So, but now you're seeing, in Illinois just last week passed, if you're going to use AI in HR, you have to disclose it. The proposal in Colorado also has that requirement. There's one going through in California, in addition to the EU under the EU AI Act, which says use of AI in HR for some of the areas we're talking about is a higher risk, and the higher risk is going to require that consent and disclosure. So what does this all mean? Right now, if you want to outside of those certain areas, that's completely up to you as an employer, whether or not to disclose that. We can't mandate it here. So the bigger, larger issue, and I think this goes into the problem that I always get asked is, hey, EEOC, where's the law enforcement action? Everybody knows that these big cases are that these big, large corporations are using all this AI, HR tech, because you can apply for a job 24 hours a day. You can have an interview 24 hours a day. You can chat, you can discuss with the applicants. Obviously, there's AI. People are getting rejected in the middle of the night. Why aren't you doing anything about it? Where's the law enforcement? And I say it's difficult because without that consent, how is the candidate supposed to know? If the candidate doesn't know how that they did not get the job because of potential algorithmic discrimination, because they never knew an algorithm was involved, how are they supposed to come to the EEOC to exercise their civil rights? And let's say even if they did, say they knew that an algorithm made an unlawful decision. There's not a form on our EEOC charge box, which employers have to sign under oath to start our cases, for algorithmic discrimination. It was the same thing we went through during COVID when everyone wanted to know, tell us about the COVID vaccine cases. We know everyone's running to the EEOC claiming religious discrimination, claiming disability discrimination because they don't want to get the vaccine and the employer is requiring them to. What are the stats? Well, there wasn't a box on our charge for COVID, vaccination cases, and there's not a charge for algorithmic discrimination. So it would have to come in under age discrimination. It would have to come under sex discrimination. And then in the 80,000 plus new cases we get, in addition to the over 80 plus thousand cases we have from the year before, we would have to start the investigation and then see anecdotally, or when we start the investigation, that AI was involved, assuming they even knew that. So it's difficult from a law enforcement perspective right now. And that's where states are trying to change it. And states are trying to say, disclose it, give them the rights, in some places, even giving opt-out rights, et cetera. We're starting to get there. So the employee knows. And, if you think about where employment discrimination has been as far as employment advertisements being discriminatory, and a lot of these cases are on the front end side, we weren't hired because of the algorithm. If you think before the civil rights era, some of the really classic employment discrimination cases, and it wasn't employment discrimination at the time because there wasn't these laws, the black and white sign in New York City, no Irish need apply. Everyone's sort of seen that. Or there's just Google old job advertising. You see no women of childbearing years apply, like in the job description. It's crazy looking back. But at least then, you're being discriminated against because the employer is literally telling you you're being discriminated against. Here, in some of these AI hiring cases on the advertising side, if the algorithm doesn't want to show you the job description or the employment advertisement because it was programmed not to show it to men or programmed not to show it to disabled individuals or older workers, the very existence of that job is being withheld on the protected characteristic, which you could be a claimant for as long as you're qualified for the job, but you don't ever know because the algorithm is withholding that for you. So that's even the next level of how difficult, but also how large these cases can and will be, because everyone who didn't see that employment advertisement because the algorithm was biased of who to show it to is a potential claimant there. And you're talking about maybe millions of people. So it's a long-winded way of saying, until there's a change or employers start voluntarily disclosing that they're using algorithm, which of course, from a liability and risk perspective, they don't want to do that because then every time somebody doesn't get a job, they're going to blame the AI tool. As we see, having everyone who's worked in in HR knows that the employees will blame the applicants for not getting a job will blame something. So it makes it a fresh target when in some cases it's really not the algorithm. So it's a very complex situation, but that's where it's so important to watch what states are doing and what foreign governments are doing in our space, because everyone wants a piece of this now. Everyone wants to legislate in this, especially when it deals with employment, housing, finance, credit, some of these more civil rights issues.
You bring up such a good point about there's no box to check whether it was for COVID or for algorithmic discrimination. It forced me to ask this question. It feels like when it comes to employers exercising AI responsibly, there may be two levels. There's what you talked about, which is consent notification. And then there's another level, which is explainability. So even knowing that an algorithm was used, if I may not know whether or not I was discriminated against unless I know why the decision was made. Will there ever be a time when that level of disclosure you think is required?
I don't know. That's a really tough question to answer because then, are we now starting to put more regulations on employers using AI than using humans? Because you don't have to explain that now. All you have to explain is we went with another candidate that's more qualified. Every standard rejection letter. And so if we're going to start regulating and requiring all that, if you're using advanced technology, that could be potentially less bias and allow individuals who historically been marginalized and not been able to even get those interviews, having to disclose all these different areas of it, which may cause them to believe it's discriminatory or even opt out, or employers just to abandon the whole thing because of all these new governance requirements. We may not make progress on that. So, that it gets very complicated when you start talking about this, but this is what a lot of legislators and civil rights groups are pushing for, that additional requirement, because we don't trust the algorithms. And that's largely because, like me, not technologists, we don't know how the algorithms work. And I think, I've been trying to dispel that and saying, well, you know what? We don't need to know how the algorithms work because let's look at the results, right? And if the results are completely riddled with bias and there's not a single woman in the results, something happened. And why did that happen? Was it because there was no women in the applicant pool or very few, some of those classic bias examples? Or did somebody tell the algorithm to do something unlawful? And that's where I was trying to get into in the differences. Both those examples are illustrative of the design issue. Can the AI vendor account for extreme discrepancies if only one woman applies out of 100 applicant? Can you make the algorithm sophisticated enough to know that, to not look at that and not think that the number one characteristic must be of men because only men are applying? And what are the actual underlying skills that everyone has neutrally? Can the algorithm account for people with disabilities? Can the algorithm account for people with heavy foreign accents? A lot of these classic examples that they may not be able to pick up the interview as much as somebody who speaks fluent American, right? That's on the design side. As corporate users and buyers, you're not going to be able to control that. But what you can control, if all that can be accounted for, is your internal use on that. And just like any other policy and procedure you have within your organization, if somebody misuses corporate resources or does something unlawful, they need to be potentially terminated. And that's where I've been raising care in the HR industry to saying, like, look, if you're going to use these tools, make sure that only the people who have access to them have been trained by the vendor, have current EEO training, that they know that even though these tools, and you've seen some of these HR tech tools give you more data about candidates than you could ever possibly imagine, including decisions you are not allowed to make a hire on, right? And they're just doing that not to violate the law, just to show you statistics and how it lines up with your current workforce, your prior workforce, what your workforce can look like. I'm not saying that it's wrong. It's just the more information you have, the more somebody who's not trained can use that to make an unlawful decision with a few clicks. And that's the danger here. And that's internal on you. That's not, yes, maybe it's the vendor designing that and allowing you to see all that data, which you can maybe request not to. But even so, we're not saying you can't see all that data, but if you use it the wrong way, you're going to be liable for that. And that is controls you can put on internally to make sure that doesn't happen. So that's where I talk about the proper use of it, not just the design. But again, it's all on you as the user. No matter what happens, whether it's the algorithm making a biased decision because of an improper data set, or the algorithm looking for something, a skill that it picked off of, somewhere on the internet that's not relevant to your job, but it sounds good, right? Or somebody using a few clicks to eliminate tens of thousands of disabled or women from, the applicant pool, you're going to be equally as liable. And that's what's so tricky again.
Unbelievably, we're about out of time. This is going to have to be the first discussion in a multi-part series, if I can lean on you to maybe come back. But look, you're not getting off the hot seat without answering one last question for me. And this one's kind of unanswerable, but I'm going to ask it anyway, because you know what? It's not that often that I get to interview commissioners of the EEOC. My biggest source of angst when it comes to employers and the responsible use of AI is that for as long as it takes whether it's federal or state, even local governments to adjudicate this or codify this into law, we're giving a lot of employers a free pass. And as an AI optimist, I'd like to believe that the private markets will self-regulate, and a lot of well-meaning, well-intentioned leaders will do the right thing, maybe even come together and kind of form private agencies to regulate the industry while these laws get codified. I know you're biased because you're the commissioner of the EEOC, but is there a view of the world where maybe we could expect some self-regulation to happen before there's formal laws made?
This is probably the easiest question I've gotten to you from you today. And I've been a proponent of self-regulation. I actually wrote a whole paper, which I will send you, that you could link, on self-regulating in the HR AI space. And in that paper, I discuss about policies and procedures and why HR should take the lead on this within your organization. Because you've been through this before with HR in many of the examples I said before, and also just because of what you're dealing with. And if you look at what these state and foreign governments are requiring when they're saying, okay, if you're going to use AI in HR, you have to do a bias audit. Okay. Well, what does a bias audit mean? If these new, if different governments are going to require this new auditing standard, well, how do you do it? And you know what happened? They all said, whether you're in Brussels, whether you're in Sacramento or New York, look to the EEOC, how to do a bias audit, because their bias audits for the 1978 Uniform Guidelines and Employment Selection Procedure is the well-known standard on how to test for disparate impact in employment decision-making, which generations of industrial and organizational psychologists have been tested, have learned how to do their practice on. So I say that in the sense that now, if we're starting to see a lot of commonality between these new laws, and what are they? The pre-deployment audit, the yearly bias audit testing, the testing as you change some of the metrics for the job, the consent, disclosure, posting of those audits. Those are all things you can be doing now. And the more you do now, whether it's building those AI policies publicly, which you've seen a lot of the big tech companies, and in that paper, I talk about how Microsoft, Amazon, Meta, Google, IBM, you name it, have all put their policies out there with their huge AI ethics committees for free on the internet. So at a macro level, you can adopt those. And so is the White House with the Blueprint Bill of Rights, with the executive order. You can adopt those from the outward principles. And then within HR, you already have some of the strongest policies within your organization. And how are you going to amend those, related to using AI? And then with the audits, using our standards from the 1970s, we have a chance now, before an employment decision goes live, right? When you have a new hiring way to assess potential candidates, you do before, you had to do it and hopefully nothing wrong happened, right? Here, we can test it in real time with each individual skill we're putting there to see if it has a disparate impact on certain groups of employees. And then if it does, we can abandon that and then change the metrics to see if there's a less discriminatory way to do that. And if you do that in advance without us involved, if the EEOC shows up, you then again have records of how you were a good faith employer, of how you selected the vendors, of why you picked these policies, of the controls you put within your organization. And before you ever let that AI make a decision on someone's livelihood, here's what you did. And here's where you felt comfortable, where you were getting the best candidates and not discriminating as much as some of the other potential initial ways you did. You're just going to be in such a better position because you've prevented that discrimination from occurring, number one. And then number two, think about all the cases we have and the limited resources we have here at the agency too. So we have two cases of employment discrimination, algorithmic employment discrimination. Say we actually know, right? We go to that first company that says, whoa, here's all our policies. Here's all the testing we did. Here's the methods we use. Here's why we select this vendor. All these things we discussed this whole podcast. Versus the other one saying, I don't know, we use this vendor because they promised us perfect diversity, equity, inclusion. They promised us the best hires, and we instituted like we instituted our financial SaaS software, just like any of that. Go after the vendor. They're the ones with the data. They're the ones who designed it, not us. Who's going to be in a better position? So that's why I keep saying that instead of just saying, well, we can't buy these programs yet until regulation comes. We can't invest in these programs until regulation comes. We can't develop these programs, whichever side of the coin you're on here. You're saying, okay, we can, but it's going to cost a little more. But if that costs a little more to build those controls, to do that governance, to do that testing, you're going to just be in a better position knowing the tools work as you intended versus not ever even instituting them because of that fear of liability. So I've been a huge advocate on that. That's sort of where my conclusion and passion has been in this area. And just take care of this of yourself using our longstanding guidelines. And we've put out guidelines at the EEOC, which you can find at eeoc.gov/AI, on the issues we think are most important. Number one, disabled workers. How are you going to ensure disabled workers can use these tools? How are you going to ensure that for all workers, that these tools aren't improperly asking for medical information? A lot of the basics when it comes to Americans with Disability Act. We've also put out guidelines on how our testing requirements, which was really designed for organizational testing on Scantron and Pencil, on how that actually equates to the same kind of underlying assessments that these AI tools at the end of the day are actually doing to candidates, and how you can do those audits. In the federal contracting space, the OFCCP has put out also principles, and everyone is saying, here's all the information of what we're going to look at, and we're providing it to you. So I think this is what needs to happen now. It also gets rid of some of the fear and some of that hesitation.
I look forward to reading that paper. I'll of course share it with the in the show notes, but I'm glad to hear you're a step ahead. I should have assumed that. Well, hey, gosh, we're way over time, and we of course went way off script, which was great about this discussion. I learned so much, and I hope listeners did as well. And I'm already looking forward to the sequel. So you're definitely coming back, whether you like it or not.
We can do a whole nother podcast unrelated to technology, just issues in HR, old-fashioned issues.
Where can the audience learn more about you and the great work that you're doing?
I'm happy to connect on LinkedIn, and please reach out to me there, and I can provide any of these resources. And look, the bottom line is I am not in the meetings when VCs are deciding which companies to invest in. I'm not in the meetings of what companies, what entrepreneurs are trying to decide what to tackle, and certainly not in the meetings of the vendors selling into the HR departments. So there's a lot of questions that rise in those meetings that I don't get to know about, just because I'm not, buying this software. I'm not developing it. And I think the more we can circulate those questions, the more we can raise those issues, gives us better awareness of then how to put out the guardrails and the principles under the confines we have, which is the Civil Rights Act.
Well, on behalf of, I think I can fairly say Americans everywhere, thanks for your service. And I can also say confidently, wow, yours are some big shoes to fill when your term expires. So it's going to be you're a tough act to follow.
Good luck to who's next.
That's right. Well, hey, Commissioner, this has been an absolute pleasure. Thanks again to Thomas Otter for the intro, and all the best with the rest of your term.
Thank you.
Well, gosh, that's all the time we have for this week on AI and the future of work. As always, I'm your host, Dan Turchin from People Rain. And of course, we're back next week with another fascinating guest.